So, all of you have probably seen all the other breakdowns already about the prosecution's response to the state's motion for change of venue. So, I'm not going to go through it page by page, but I'm going to point out a few of the things that I think are very important. Now, the first thing I'm going to bring up is Idaho code regarding keeping a trial in the county where the offense happened. Because a lot of people are like, why is Bill Thompson fighting so hard to keep it in Latah County? Is it because he thinks a biased jury pool will get a conviction? You know, maybe he thinks that, but it is the prosecutor's duty to fight to keep the case in the county. And here's the reason why. So, Idaho Criminal Rule 19, place of prosecution and trial, says unless a statute or these rules permit otherwise, the government must prosecute an offense in the county in which the alleged offense was committed. This is why prosecutors have an obligation to try to keep the trial in the county where the crime took place. That's the community that was harmed. The state tries to keep the trial in that community. Now, as you read the document, you'll see that the state methodically picks apart the defense's arguments where they use case law. One of them was a situation where there was chaos in the courtroom, where reporters were right up at the table with the defense and the prosecution and just running rampant. And Judge has already said he's not putting up with that in his courtroom. There's one camera. It's going to be the one that shows the trial. Things have been on his website on YouTube. Reporters cannot have cell phones in there. They can't have cameras, etc. So he's put a lid on that already. And so case by case, they shot down Anne's examples. And, you know, I didn't expect any different from Anne. It's a defense attorney's job to throw things at the wall and see what will stick. But the prosecution did go through and shoot down all the different cases that she cited. But where I thought the prosecution made the most sense about not moving it was her choosing to move it to Ada compared to Bannock or Canyon County, because 4 counties were surveyed: Latah, Ada, Bannock, and Canyon. But the prosecution points this out about Ada, which is Ann Taylor's choice. So here it is right on page 2. It says, the court should decline the defendant's invitation to parse and split hairs over an incomplete data set to reverse engineer a transfer to Ada County, which according to the defendant's own experts has received the second highest amount of media coverage in the state, and where a statistically greater number, albeit slightly, of the survey respondents familiar with the case believe the defendant is guilty. So let's take a look at it. So it says from Latah County, approximately 67% of survey respondents who knew about the case reported that Brian Koberger is guilty of murder, with 25% indicating he is definitely guilty. Now, if we look at Ada County, approximately 93% of survey respondents had read, seen, or heard about the case, and 68% believe he is guilty of murder. So 68% there. So that's true. There's really not much of a difference at all. If you went and you looked at Canyon County and Bannock County, prejudgment was also high, but it was less, 69% and 76%. That right there is crazy. Like, basically, Latah County and Ada County don't have a lot of differences with presumption of guilt. She's wanting to move it to Ada. One can only think it is because of logistics and not truly because she believes there's more chance of a fair trial in Ada. Yes, I understand there's a bigger jury pool. However, there is the voir dire process. So no matter what county you're in, you're going to have the defense and the prosecution be able to question the people they're going to seat on the jury to determine which end of the spectrum they may be on partiality-wise, whether they lean towards guilty or not guilty. And they're going to ask them, are you capable of deciding based only what you hear in the courtroom? Because just because somebody may have heard a lot of media publicity right now and maybe thinks he's guilty or he's not guilty, once they're sat on a jury in the courtroom, they're going to hear a whole lot of different things. They will be shown all the exhibits, they will hear witness testimony, and they are told they can only decide based on what's heard in the courtroom during the trial. That's the difference. So you're not looking for jurors that have never heard about the case. You're looking for the ones that can make up their mind based solely on what they hear in the courtroom during the trial. So that's the biggest thing there. And I truly, on just what they're showing there, don't think that it should be moved to Ada County on the basis of getting an impartial jury. I think why Judge will decide to move it is just going to be on logistics. It's going to be on better security in Ada County, bigger courtroom, more hotel rooms, etc. But we will see. And then I'm going to point out another few things I thought was interesting in here as well. Now, here was another interesting part. So the survey data provided by Edelman is inadequate to justify the change of venue. And it says a glaring omission in the data is the lack of any information about the number of individuals who were contacted but chose not to respond to the survey. This is important because non-participation bias can change the outcome. Yeah, and that is kind of interesting. And it's not like he didn't have time to compile all that, because remember, Anne filed a motion asking for extra time. So it would have been interesting to see if that would have changed some of the results or not. Now, this page is interesting because this was the section where Jules, of all trades, got herself kind of out in the weeds, misunderstanding what was being said. And I think it's because she missed one of the words here in this paragraph, but it says the court should also consider the fact that while the survey respondents were told that the poll was not political or sales related, these survey respondents were never told why they were being asked questions. Now, Jewel read that as they were never told they were being asked questions. No, it was they weren't told why. So they didn't state whether it was on behalf of the defense or on behalf of the prosecution, or like it says here, they had no way of knowing whether the poll was being done on behalf of the news media or a true crime blogger or for some other purpose. So it said while they were told their responses would not be made public, they were never told whether they were being recorded. So that makes sense that some may not have answered the survey because they didn't know why it was being done. Or you could have had some that would have answered the survey if they'd known it was on behalf of the defense, for example, or on behalf of media. And if they didn't know if they were being recorded or not, that makes a big difference too. All they were told was that it was a survey company who was conducting a survey of trials in the area, like cases in the area. So that is also concerning that Edelman did not compile stats about that, about how that could skew the results, but also why, when people were called to conduct the survey, they weren't told who it was being done on behalf of. So that is interesting. But no, they were told that they were being asked questions. They just weren't told why they were being asked questions. So that was kind of humorous that she got confused by that. So this page brings up a good point too. It says there are two critical questions in the defendant's motion to change venue. The first question is whether a fair and impartial jury can be convened in Latah County. And if not, the second question is whether an alternative county would better safeguard the defendant's right to a fair and impartial jury. After all, why would the court change venue to another county that has nearly the same media saturation as Latah County. Yet the state and the court were not provided a comprehensive list of survey responses across all 4 of the counties surveyed. In fact, Dr. Edelman's report focused primarily on Ada County as an alternative venue, despite the fact that Canyon and Bannock counties, the other 2 counties surveyed, both received astronomically less media coverage than Latah and Ada County. Yeah, and that is a little concerning. Why is there incomplete data for those other 2 counties? Is it because Anne asked him to focus only on Latah and Ada? Or did he decide to just focus on those 2? And he had plenty of time, again, so why was there not complete data on Bannock and Canyon County? It just seems really, really interesting. And as far as saturation, of course, Ada County was going to be saturated. The media center for Idaho is Boise. The Panhandle gets their news from Spokane area or Boise area. So, of course, Latah was going to have lots of saturation between the news media in Spokane and Boise, but the rest of Idaho, particularly the population centers there in Ada County, was going to be the Boise news. So, it's a no-brainer that they were going to heard about the case more in Ada. So, yeah, this is a little concerning. So I'm just going to skip ahead now to the conclusion because it's more of the same about the survey and about media bias. You can go on the Idaho Cases of Interest webpage to read the full document, but I think enough people have parsed through all of this that I just wanted to point out what was most interesting to me. And the conclusion says the defendant has failed to meet his burden of showing the change of venue in this case is necessary or convenient. The court should decline his invitation to ignore well-settled precedent establishing the voir dire process. The court should also decline to relocate itself, the state, and the scores of witnesses hundreds of miles only to face another jury pool with similarly high media exposure. Defendant's motion should be denied. So, yeah, I think Anne would have a much better argument for moving this if it wasn't Ada County she was suggesting. I think Ada would have just the same issues if you're worried about a fair or impartial jury as Latah County. And it's interesting that Edelman did not do complete information for Bannock and Canyon, nor, as they also pointed out in the document, did they not survey closer counties like Nez Perce. So it feels like someone was gunning for Ada from the start and wanted it there. Whether that's Anne or Edelman, I tend to think because he was just hired to do the survey that it was Anne who was directing that towards Ada. But I don't want to just come outright and say, yes, she told him to do this, because we don't know for sure, but it's awfully strange. And Ada does not appear to be a good choice to move it to. However, I think, like I said, Judge will go ahead and move it there just because of logistics. Courtroom safety, size, having enough hotel rooms, etc. is going to be a huge deal. It really will. Latah is just a small county, and you're going to be dealing with logistics, a logistical nightmare. But I don't think you're going to have any difference in a jury pool between the 2 counties. And they mentioned voir dire again in the conclusion, and I think that's going to be the most important part. You will never find an impartial jury, but what you can find is people that are willing to decide based only on what they hear during the trial and not anything they heard outside of the courtroom. So that's going to be the important factor. Now, of note, I did not mention footnote 5, the infamous footnote 5, about whether he was near the house or not, because I'm going to do a separate video on that tomorrow. When I first read it, I was alarmed. Then I read it again. Then I read the probable cause affidavit. Then I had different thoughts. So I'm going to do a video on my thoughts about footnote 5. So that'll be coming. And again, you can read this full document on the Idaho Cases of Interest website. I encourage anyone that's not familiar with that page to get on there and check it out.